Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. If you've been watching my videos, you already know that the Fourth Amendment protects you against unreasonable searches and seizures. And of course, your home perhaps gets the most protection under the Constitution. But there are exceptions to the warrant requirement. And in this video, we're going to discuss knock and talk exception to the warrant requirement and consent, and really what the police shouldn't be doing when they're coming up and approaching your front door. In this video, we're discussing United States versus Martin. This is a Ninth Circuit case from May 2022, and it deals with the Fourth Amendment. The Fourth Amendment protects you against unreasonable searches and seizures. And generally speaking, police needs to have a warrant before they can enter and search your home. And when we're talking about your home, we're including curtilage. Curtilage, under the Constitution, is the area that surrounds your home, and that the Supreme Court has acknowledged that you have an interest in that area, and you want to make sure that people don't enter that area and don't trespass upon it, even if you don't have fences around your yard. But there are exceptions to the warrant requirement. One of them is knock and talk. This is the exception that permits police to encroach upon the curtilage of a home for the purpose of asking questions of the occupants. It's exactly what it sounds like. Police comes up to the front door, knocks, and wants to talk to the person inside. Why do we allow police to enter this curtilage area for the purpose of knocking on the front door? Well, it really comes from implied consent, which comes from customs. In the United States, regular people can come up to the front doors and knock and try to talk to the owner or the occupant of the home, including the police. Police can do everything that a regular citizen can do. None of us would ever say that this is a trespass because we have customs. We have given implied consent to people to come up to the front door and knock. But of course, there are limits to this knock and talk. And in this case, we're going to talk about what the police shouldn't be doing when they're coming up to your front door. In this case, 6 officers approached Miss Cormack's apartment. 3 of the officers had their guns drawn and pointing them at the front door and the front window that was next to the apartment's front door. Then one of the officers knocked on the front door and the second one yelled, "Open the door." Miss Cormack answered the front door, and the officers lowered their guns but did not put them into their holsters. So they were still holding them to their side. And then they told Miss Cormack that we're going to need you to come out. So Miss Cormack came out of her apartment. And at that point, the government says that this was a voluntary conversation between Miss Cormack and 6 officers. Even though there was an intense sort of interaction in the beginning, by the time she's out of it, the guns are to the side, and the government says that this is a voluntary conversation. But again, in order for this to be a consensual conversation, it has to be voluntary. But the Ninth Circuit doesn't agree. When we're talking about consent, think about it. Miss Cormack had nowhere to go. There were 6 officers that were still holding their guns out, and they were not holstered. They did not ask her whether she wanted to talk to them. And then at some point, Miss Cormack actually asked permission from the officers if she could go back into the apartment. And at the whole time, she was telling the officers how upset she was the way they conducted the initial encroachment into the area and the initial conversation with her. Through this conversation, the officers find out that Mr. Dwayne Martin lives in the apartment. And because they get this nexus between the apartment and Mr. Martin and the crimes that are being investigated, they get a warrant to further come back into the apartment and search it. During the search, they find a gun that links Mr. Martin to a crime. He argues that that firearm needs to be suppressed, meaning that the jury cannot ever hear about the gun because it was found illegally. And the Ninth Circuit agrees. It says that the officers inappropriately conducting themselves. This is not how knock and talk works. There was a lot of force. The conversation was not voluntary. And so the way they find out that Mr. Martin lives in the apartment is through pressure and not a voluntary conversation. Because taking that information out of the warrant, taking the information that they received that Mr. Martin actually lives in the apartment, the warrant itself is now tainted, meaning that the search was done as though the officers never had a warrant, which would be an illegal search of the apartment. I hope you now understand a little bit more about knock and talk, about how consent works, and what the police should be doing when they're conducting an investigation and coming up to people's front doors. They're not supposed to pressure you. They're supposed to do what a regular citizen would do. Knock on the door and ask a few questions. And if you don't want to answer them, you don't have to, because that's our custom. And the Constitution protects you. The Fourth Amendment protects you against unreasonable searches and seizures. If you enjoyed this video, please click like, subscribe, hit that bell notification button, so next time I post, you'll be first to know. Thanks for watching.